attorney Jeff Vastola.
Well, good morning, everybody, and thank you so much for tuning into the show. Thank you those that are listening to the radio. Thank you to those that are watching on Facebook Live. I am Jeff Vastola, and I am your host here for the next 30 minutes to give you free legal advice. If you have a question of your own and you want some free legal advice, then just call into the show. You just heard the number. It is 877-850-8585. If you don't have a question of your own, you just want to sit back and listen, that's fine. I've got some topics planned. I'm going to be talking about bed bugs. Somebody called me this week and wanted to make a claim for bed bugs, so I'm hoping that person calls in. I suggested that he should call me right away Saturday morning at 7:30 so that we can talk more about his claim and specifically the option of using a small claims action. So I have some case that I want to talk about, cases, plural, that I want to talk about from the Florida Law Weekly. I didn't get to this last week because my topics took us through the entire show and some phone calls. Of course, I give priority to those people that call in or to anybody that may type in a question. And again, my apologies if I don't see your question as it scrolls up on the screen because it doesn't stay up on the screen very long. But I do try to watch the show after the fact, and I do try to respond to whatever was typed in the form of a question. So, Jay, I did get your question last week, and then I did respond, but thank you. It's always good to have a little entertainment on the show. Let me see. So follow me on several different platforms of social media now. You can follow Vastola Legal on not just Facebook, but Instagram, Twitter, YouTube, LinkedIn, all those different ways. And we're going to be expanding soon. We're going to be going out with physical locations into Okeechobee and then possibly even further south. More on that later. But we are expanding our practice. I currently represent clients throughout the state of Florida, but finding that it's probably a good idea to have additional office locations to help those that are a little bit further away. So that's the concept. You can go to my website to find out more about us. My website is vastolalegal.com. Vastola is spelled V-A-S-T-O-L-A. And I'm going to tell you the reason why in just a moment. I have a toll-free number that you can contact me 24/7 and ask me anything you want. And that number is 833-VASTOLA. Good morning, my beautiful wife and my wonderful mother up in Tennessee. So 833-VASTOLA is my cell phone number. It's actually a toll-free number that forwards to my cell phone. You can use it 24/7. If I don't answer the phone, leave me a voicemail message and I will call you back. But that's 833-827-8652. That's the numerical number. And thank you again for all of you guys tuning in. The case law update that I want to talk about, there's several of them. What you should consider if you want to change your name. If you use dealer tags, make sure, dealer tags on your vehicle, make sure that you're using them for a legitimate purpose and you're not doing illegal things. Do you want to disqualify the judge on your case? It might be harder than you think. Something I've talked about several times in the past are what are called forum selection clauses, where it's predetermined in a contract where your lawsuit can be filed. One of those was recently enforced down in Miami, kicking the case out all the way to California. And another one of these GPS tracking cases in a criminal context, when a criminal is actually convicted using information taken from GPS devices in vehicles. The electronic footprint that we are all leaving behind is absolutely amazing. You would be surprised the amount of information that just day to day you are involuntarily uploading into the cloud that federal agencies have access to. Don was calling last week about some additional information on the dental malpractice claim. We'll see if we get a phone call today from him. But if you would like to call into the show, the number is 877-850-8585. Feel free to call in with whatever you want. I do have topics planned today. First, very interesting, at least for me, and if this does happen, if this bill passes into law, then what I talk about probably at least every other week in having the right kind of insurance and how Florida doesn't require what is the right kind of insurance, in my opinion, those conversations are going to completely change, because what's happened is on February 15th of this year, Senate Bill 54 has passed its second Senate committee with some changes to the bill, but it's looking like it's gaining momentum, and it actually might become law. And if it does, what it's going to do is eliminate what's called personal injury protection insurance in Florida, oftentimes referred to as PIP or PIP, and most oftentimes referred to by lay people as no-fault insurance. Oh, I don't have to worry about it. I've got no fault. It doesn't matter who's responsible for the accident. I have no fault. That term is thrown around so loosely and so inaccurately that, in my opinion, is going to be a really good thing when PIP goes away. Now, it will benefit some people. It might not benefit others. But the way it's going to change is if Senate Bill 54 becomes law in some format, mandatory bodily injury coverage. Understand that bodily injury coverage is not required in the state of Florida right now. When you purchase an automobile coverage policy, and I apologize for everyone that's heard this before, but when you purchase an automobile insurance policy, you can get all kinds of upgrades. It's like buying a car, and you see the sticker price on the car, and you find out it basically comes with a steering wheel and a seat. And then you have to pay more for leather. You have to pay more for a sunroof. You have to pay more for this and that. It's somewhat analogous when you're buying an automobile insurance policy. There are some things that are mandatory. The seat and the steering wheel are mandatory, but everything else is optional, and everything else is going to cost you more money. Right now in the state of Florida, and the way it's been ever since I've been a lawyer, let's put it that way, and actually many, many years before that, bodily injury coverage, which is the type of insurance on your automobile policy that will protect you by paying other people that you may hurt in an accident, was always optional. If this Senate Bill 54 passes into law, now it will be mandatory. And what it's going to do is it's going to replace mandatory PIP coverage. So instead of having mandatory PIP coverage, which pays for your medical bills at the rate of 80% of what the insurance company deems reasonable, lost wages at the rate of 60% of what you can prove, and lastly, it pays death benefit of up to $5,000 if somebody should die in a car accident. That's all going to go away, and the mandatory bodily injury coverage amounts would be, it depends on whether you are a student or a low-income person, and we'll get to that in a moment. But if you are a regular person, so to speak, the mandatory minimums, now you can always get more than the minimum, but the mandatory minimums are going to be $25,000 for one person, $50,000 for multiple people. So the way you see that on your policy is it's going to be written as a 2550 or a 25,000, 50,000, and a minimum of $10,000 for property damage. So that's not going to change, because right now the state of Florida requires that you have at least $10,000 of property damage. Now, quick tangent. If you only have $10,000 of property damage and you are in, let's just say, the South Florida region, you are very likely underinsured. And that's important to know. I was dealing with some very, very close personal friends of mine recently, been involved in an accident. Liability was somewhat disputed, but nevertheless, the other people involved in the accident in a very expensive vehicle made a claim against them, for my clients, my friends, for negligence. And the amount of property damage that was caused in the accident exceeded substantially the amount of property damage that they had on their policy. So you may ask, well, what does that mean and why does it matter to me? Well, if you have a contract with your insurance company where the insurance company only has to pay up to $10,000 to fix somebody else's car if you cause an accident, but the property damage is $50,000 to that other car, and just so you understand, it could be a lot more than that. If you look around at any given stoplight down here, you'll see vehicles that cost well in excess of $100,000. And if you damage that vehicle to the point that it's totaled, then you have to pay for the whole car. So $10,000 of property damage, which could be used to fix or to replace a car, is woefully inadequate in my mind. It should be at least $50,000. Insurance is one of those things where you get what you can afford. but please consider getting more than the state required minimum coverages. Those might be fine if you're, living in a very rural area in the middle of the state somewhere, but down here where it's very populated and there's a lot of expensive cars, I would recommend getting more coverage. Now, I mentioned if you are a student or a low-income person, the question becomes, how are you going to prove that you're low income? No one really knows yet. We'll see how the bill plays out. But if it says college and high school students and those making less than 200% of the federal poverty income, which I don't know what that number is, we can figure that out if you want, will only have to have $15,000 per individual, $30,000 for multiple persons, and again, that minimum of $10,000 for property damage. Now, here's the interesting thing. So they're saying, okay, if you're a student or if you're low income, you don't have to have $25,000 per individual. You only have to have $15,000 per individual. Well, I'll bet you this. Call your insurance agent and say, how much more is it going to cost me to go from $15,000 as a college student or a high school student to $25,000 on my 6-month policy? What's the increase in the premium? You're going to laugh when you find out what the difference is in the increase in premium, because it's probably something along the lines of maybe $10 every 6 months to go from $15,000 to $25,000. So for what reason they're making a really big deal about giving students and low-income folks a break in what's required? For those people that are in the know and know what the premium differences really are, it's almost a little bit insulting what the differences are, because when you look at it from the other angle to say, I could actually have $10,000 more of coverage in protecting other people if I paid $10 every 6 months. Now, that's my guess, but it should be pretty close to that. It might be $25 every 6 months, but the premium increase is not really that substantial at all. So we'll see what happens with all of this, but this is very, very big news in my industry. If you own a vehicle, it's going to affect you. They're suggesting that the premiums, automobile insurance premiums overall, are supposed to go down because of this proposed legislation. We'll see how that goes. For any of you that own a home in the state of Florida, and if you're in the market right now to get new homeowners insurance, I'll tell you personally, and this is one of the reasons why I don't want to use the word despise because that's strong, but I really dislike the way insurance works, in that if they operate at, I'll use the word a loss, I doubt it's a loss. If they operate at not making enough money in 1 year, then next year they can jack up their rates approved by the state of Florida and then make up for all of those suggested losses or not enough profit so that they can recoup. And that's exactly what's happening right now. And my insurance agent, my personal agent, is shopping my homeowner's policy because my premiums have not gone up by the cost of living, 3% inflation rate, whatever you want to call it. They have gone up by about 1/3 of what I actually paid last year. And to me, that's absurd. That's unacceptable. But there's nothing you can do about it because insurance runs the world. So I see that my friend Andy is watching. Good morning, Andy. I saw from Facebook that you are celebrating an anniversary with your wife. So congratulations, Andy. Enjoy. I think you're down in Miami or somewhere south. Hope you're having fun. That news on the change in PIP law was probably my major topic. I was really kind of hoping that this guy that called me on my phone to talk about his bed bugs issue would call the radio show, because that makes for very interesting conversation, I promise you. The number to call into the show, you may not have a bed bugs issue, but if you have anything else that you want to talk to me about, is 877-850-8585. Call the show. We'll be happy to talk about anything you want. But if you're going to call the show and complain about a hotel, don't give us the name of the hotel, because I don't want to get any hate mail or threats of defamation from some person or some company because we talked about it on the radio. But let's talk about bed bugs, because they're gross, especially if you've ever seen the picture of the bug under the microscope and all that. But, people get the willies when they think about staying in a hotel where other people have been, and it's just not clean. It's not clean to the point where there are bed bugs in the bed. And the reason why I wanted to talk about this, probably not for very long, but just at least for a few minutes, is because this is actually the second bedbugs phone call from a different person that I've had in a month. So be careful where you stay. Be mindful of, what you might see on your skin and everything if you're going to stay in a hotel longer than one night. But there is a remedy. The first thing you have to do is get checked out medically. They're not life-threatening, and the little welts that they leave will go away, but you probably ought to get checked out, get treated, and then, for your inconvenience and the hassle and everything else, theoretically there's a remedy. The reason why I spoke with this individual on the phone very briefly and said I'd rather that you call the show is because it's not something that I'm going to be able to help you with for practical reasons. But small claims court is an option. Small claims court is there for all different kinds of grievances. As you can imagine, you may have a breach of an agreement to sell something on Facebook that goes awry. I've been using the Facebook marketplace recently a lot because it's really interesting what people will put on there to sell. But anything small claims court jurisdiction was just recently increased to $7,500. So if your dispute is $7,500 or less, then use small claims court because you don't have to have a lawyer. Technically, if you are an individual bringing a claim of your own, you don't have to have a lawyer, even if you are in the county court jurisdiction, which is right above small claims, which is everything up to $30,000, from $7,500 to $30,000. And then above that is the circuit civil division, which is from $30,000 plus, all the way to billions of dollars. So if you're an individual, you can, I would say theoretically represent yourself. You can realistically represent yourself in county and also circuit civil jurisdictions. It's just strongly ill-advised to do that because you'll be going up against lawyers that know the rules of civil procedure that are strictly applied and everything else. Now, if you are a corporation in county or circuit civil jurisdiction, your company must be represented by an attorney. That is a rule. But in small claims court, you or your company can be represented by you, even if you are not a lawyer. And there are specific rules that are applicable to small claims that make it easier for people that have not gone to law school. Now, if you go up against a lawyer in small claims court and that lawyer seeks to invoke the rules of civil procedure, well then, and if the judge agrees, then you may be stuck with the rules of civil procedure. And then at that point, you might want to go talk to a lawyer depending on how serious your claim may be. But I wanted to bring that up with the hopes that this guy was going to call in about his issue, because that's why small claims is there. It's meant to be an efficient, and by efficient I mean less expensive and a much faster remedy than the standard system. Standard system being county court and circuit civil. Now, just quickly, because of COVID, I've had this conversation more times than I can count already. I used to tell my clients if they would come to see me before COVID was a household name, if we filed your lawsuit today, it's probably going to take, where I practice law, which is essentially the state of Florida, but most of the jurisdictions around me in South Florida, maybe the West Coast, it's going to take at least 1.5 years to 2 years to get to trial. It just takes that long. It doesn't take that long to get your case ready. We can probably get your case ready, depending on what kind of a case it is, between 6 to 12 months. And oftentimes that's because of the defense attorneys and trying to get things scheduled. I mean, you wouldn't believe how long it takes to get a hearing scheduled these days. It's stupid. But it could take maybe 6 to 12 months to get your case ready. And then from that point on, you're just waiting. You're waiting for your turn because there's such a backlog in the court system. Well, now understand that since March of 2020, we can probably count on one or two hands how many trials have actually been held in the state of Florida. Where ordinarily in the state of Florida, you have hundreds, if not thousands, of trials happening every week throughout the state. So the backlog is immense. It doesn't mean those cases went away. It just means that they're stacking up. It's like, being at an airport where planes are trying to land and they have to circle around. I mean, to put it that way, metaphorically, your case is going to be circling around in the air now for probably a lot more than just 1.5 years to 2 years to get to trial. I'm telling my clients, it's probably going to take at least 2 to 3 years to get to trial. Now, hopefully, they're going to work something out up in Tallahassee, because there are all kinds of committees, the Supreme Court justices and everybody is working together to try to find remedies for that problem so that we can alleviate the congestion, and we'll see what happens, whether they use retired judges. There are alternative forums for dispute resolution. For example, mediation is already required before you go to a jury trial, but I suspect that mediations are going to become more frequent, probably earlier in litigation than just immediately prior to trial. And then Chapter 44 of Florida statutes has several different types of dispute resolution, which I find very interesting, because I'm not only a Florida Supreme Court certified mediator, but I am also qualified as an arbitrator, because I've taken those courses so that I can hold myself out in those ways. Now, I'm not real busy as a mediator or an arbitrator, not yet. I'm still very busy as a trial lawyer, but those are alternative means of dispute resolution that are out there, and I think because of the backlog, they're going to start becoming really, really popular, especially if you look at my junk folder, my email inbox. The number of emails that I get from mediation training places and arbitration training places, and it's just blowing up. I suspect that probably 1 out of every 3 lawyers pretty soon is also going to be a mediator or an arbitrator or something like that, just because of these new opportunities. But gosh darn, I'm already running out of time. I really wanted to talk about these cases that I find in my Florida Law Weekly, because to me they're very interesting. Let me just try to knock out a couple of these. These are from a couple of weeks ago already. So I mentioned earlier in the show, if you're looking to change your name, and if you think it's just a pretty simple process, well, I guess it's supposed to be. But if you're interested in doing it, anybody that wants to change your name for whatever reason, look at Florida Statute 68.07. This is a case out of the 4th DCA, which is right here. Now it's Broward County, which is Fort Lauderdale and all of those towns south of us. But it's still the 4th DCA, which is controlling law where we sit. If you're listening to this radio show, it's where we sit. If you're watching by Facebook Live, that could be different. But this is a case where a person by the name of Raul Medina brought a claim against the state of Florida because his petition for a name change was denied, because the judge said, well, you haven't given me sufficient notice that you're not trying to change your name because you have a criminal history. Well, the case says that ordinarily a facially sufficient petition for a name change should be granted in the absence of evidence of a wrongful or fraudulent purpose. And the case goes on to say that just because somebody has a criminal background doesn't mean that the petition is facially insignificant or insufficient, I should say. So if you want to change your name for whatever your reason, go to Florida Statute 68.07, but understand that if you're going to try to change your name because of a fraudulent purpose or a wrongful purpose, whatever that decision is by the judge, then your name change petition may be denied. Now, this individual's name change disallowance was reversed. This appeal actually benefited Mr. Medina, and he was ultimately allowed to change his name. Now, whether he's Mr. Medina anymore or not, I don't know. If you are a person that uses dealer tags on your vehicle, I'm only going to get to 2 of these cases, I think, because I'm about to run out of time. This is a really interesting case out of the 1st DCA, which is up in Tallahassee, where 3 individuals were in a car at midnight, and the vehicle had a dealer tag on it, one of those temporary dealer tags. I've seen those around, and I have an assumption that I know what they're for, but be careful if you use them, and be careful what you're doing with the vehicle, because there was an officer at the gas station where this vehicle was located. The officer said to himself, well, this is really strange. Why is there a dealer vehicle with 3 people in it at a gas station at midnight? And so he ran a search on the tag, and the officer, suspecting the crime of dealer license misuse, conducted an investigatory stop with a canine dog, and sure enough, found drugs in the car. And so the person that was associated with the vehicle or associated with the drugs this unfortunate lady, Rebecca Jane Thomas, was arrested. But it all started because the officer ran a search because he saw dealer tags on a vehicle at a gas station at midnight. So, to put it into context, if this vehicle had, thank you, Sharina, if this vehicle had a regular plate on it, and the officer said, you know what, those people look suspicious, I'm going to run this plate, this arrest probably would have been thrown out because the only reason the officer had a reasonable expectation to do an investigation was because of dealer misuse, dealer tag misuse. So keep that in mind. I'm Jeff Vastola. I am your host here every Saturday morning. Thank you so much for listening to Vastola on the Law. If you want to contact me anytime, anywhere, the number is 833-VASTOLA. That's 833-827-8652. Call me about anything. And if you want to talk to me about bed bugs, then I'll just have you call the show. Thanks for listening. Thanks for watching. Everyone have a great week. God bless. Thank you, Sharina.